Good night, Belizeans at home and abroad. This is the Belizean Affairs Show number 409. 409. My name is Leonard Brackett. I will be your host for tonight, being Friday. We will deal with some constitutional and legal case law matters, as well as constitutional revisions and the PCC recommendations to the Prime Minister. Um, as is the pattern of our show, we normally start with a short prayer, which I'll bow my head and do, and after which I'll do a short reading. So I'll proceed with that. Divine loving Father, we thank you for this privilege to come before thy presence once more. We also thank you for giving us the privilege to still be alive among our family members, friends, and loved ones. We pray that thou must bless them, each and every one of them, our children, grandchildren, great grandchildren, those of us who have, and our significant others as well. We pray that thou must bless our brothers, sisters, cousins, uncles, aunts, and all the rest of the other extended family members and friends, wherever they are, in Belize, in America, or any other part of the world. We pray that thou must bless our country of Belize, its people and leadership. Grant them wisdom, knowledge, understanding, endurance, courage, strength, perseverance, and protection. We pray that thou must bless this country of the United States itself as well, loving Father. Please bless its people, its leaders, and grant them wisdom, knowledge, understanding, and perseverance to do that which is right. And please guide them to help us gain some relief from these treacherous and tragic and devious times that we are now living through. I pray that thou must bless the rest of the world, especially those people in war zones, those who are being hurt, sometimes for no justifiable reason. Please bless those who have need of food and clothes and shelter. Please continue to be merciful upon us and help us as we present this program tonight, that we may do a program that is worthy of people's time and their attention and effort. On behalf of our country of Belize, for us these mercies in Jesus' name. Amen. Thank you for bearing with me. I was indulged in a section of the prayer, and I'll read. Let me see. I'll go to Proverbs, and I'll read one of the early books, one of the early chapters of Proverbs. That's what I'm going to read here now. No, I mean Psalms, not Proverbs. Proverbs, yeah, right here. Proverbs 9, Proverbs 13. I'll read from Proverbs chapter 8, and I'll start at verse 1. And it reads as follows. Doth not wisdom cry, and understand put forth her voice? She standeth in the top of the high place, by way in the places of the paths. She cried out at the gates, at the entry of the city, and at the coming in at the doors. And that will be a reading for biblical reading for tonight. Let me put that away before I. Of course, I got lucky there. I picked a section that relates to some of what I'm going to talk about tonight. That is in the sense of allowing wisdom, choosing wisdom, and allowing wisdom to proclaim at the gates the importance of displaying wisdom. And as I would like to say in this case, not only displaying it, but for the leaders of our country of Belize to exercise the astute acquisition of knowledge and the wise display of that knowledge, which constitutes therefore wisdom. Um, I want to start off tonight's program. I think it might be a little long, so I don't want to get into any other extra side issues for right now. I just want to go straight to the program, knowing that I'm going to need more time than we normally have allotted to the program itself. And I'm going to go ahead and read. Oh, just a minute. Please bear with me a second. I need to grab something else. Just a second. I'm sorry. Thank you for bearing with me for a few seconds. I had to go and take care of something else quickly. And in the interest of time, I also would have liked to launch the other section of our program on. Let me see if I can take a few seconds and do that quickly, so I don't get myself in trouble. Let me see. Okay, yeah, so we're live there, and I just need to activate it. No, I won't edit it right now. I'll just leave that for right now. And I'm just glad that I was able to get it activated, so the other people who are trying to listen to our program and the other with the other options, they too can share. So thank you for bearing with me as I got distracted just now trying to get that stuff done. It's taken care of. And so now we can proceed. As I stipulated earlier, the program for tonight may be a bit lengthy, so that's a little heads up for those of you who listen to our Friday night programs. And I have a lot of material that I would like to cover, and I'm almost certain I will not have enough time during the course of the 90 minutes of our program, which is an hour and a half, to be able to do so. But I'll try my best. Whatever is left, I'm going to probably postpone for next Friday. I will first read a portion of the PCC recommendations to the Prime Minister, as I previously stipulated. And I'm going to go to recommendation number 107. Let me turn this sideways, see if I can. Yeah. Item number 107. And I'll just. Most of you who have been following these teachable moments of the Constitution on Fridays would recall that our government has launched a program whereby they are attempting to make substantive changes to the Constitution and or eviscerate it altogether and create a new one without having allowed the public to learn what was in the old one so that they can have comments and help in a referendum, which is required if they're going to eviscerate the whole Constitution and create a new one. They're going to have to present it via a referendum in order for the public to buy into it. But they haven't been teaching what they're supposed to be teaching so that people can become aware of it and then be able to vote as an informed plebiscite. And that's what's required by the Constitution. Whenever the leaders of the country wants to tamper with any of our Section 3 all the way through Section 19 fundamental rights, they first have to come to the public to get their questions of the public through, as the Constitution stipulates, there shall be a referendum. They cannot just arbitrarily and capriciously decide because they are the elected officials that they're going to go ahead and change the Constitution any which way they want. It doesn't work like that. There are some parts of the Constitution that they are forbidden, that it's impermissible for them to tamper with. But they give the impression to some of the people who don't know otherwise or know better, this idea that they are elected to govern, and in governing, they're also allowed the privilege to make laws. But the Constitution also says that under Section 2, as most of you who listen to our program would recall, every time I bring it up, the Constitution is self-preserving. And it says, for example, under Section 2, subsection 1, this Constitution is the supreme law of Belize. And if any other law, you recall every time I get to that particular section, I emphasize it quite distinctly with the hope that it will trigger people's mind and recollection to the reality that there are other laws besides the Constitution itself. And those other laws are the laws that the legislator is empowered to make to help enhance the governance of the country. But as Section 2 says, which I was repeating just now, if any other law is inconsistent with the Constitution, then that other law, to the extent of its inconsistency, is null and void. But yet these jackals continue fostering on the people or browbeating the people or play shenanigans with the people or bamboozle the people into believing that just about anything that they want to make into a law is legally constituted as a law and therefore is constitutional. The legislative authority is to make certain laws, not any and all laws which transgress the Constitution, which is violative of the Constitution, which is unconstitutional, or null and void. Section 2 of the Constitution, in the beginning of the Constitution, speaks to those matters, plain and straight. If any other law is inconsistent with the Constitution, that other law, to the extent of its inconsistency, is null and void. What part of that they don't want to abide by baffles me, because every time they go to the legislature to create laws, in most instances, they are creating something that is contravening to the Constitution that they would like to alter and allow to become law. But it's not because they create it means that it's constitutional. They can create a million different laws that are unconstitutional. The fact that they create it don't make it constitutional. Belizeans at home and abroad, you need to be aware of that reality. Okay? We cannot sit by and allow our legislators or the leaders of our country to hoodwink us, to bamboozle us, to play fast and loose with our laws, and then turn around and use those very bogus laws that they create that is unconstitutional and null and void against us, the populace. Because they never make a law that's against them or that checkmates them or put them in a situation where all the criminal conduct that they're carrying on with can be checkmated. No, they don't do that. They're too busy doing other things. I won't get into all those other things because, like I said, the program for tonight is apparently going to be lengthy. And so I'll try and distract as little as possible so that I can carry out as much of this program for tonight. Anyhow, so because the government is trying to change the Constitution, they created what was then called initially Constitution Reform Commission. And we start giving them hell for it. So they turn around and decide, okay, well, you know what? We're being shamed and embarrassed, and we can't go that way. So we're going to change, and we're going to get the same thing done by going in a different direction. And we're going to just go ahead and pass a rule, an act in Congress, which they are empowered to do. But for that act to be valid, it has to meet constitutional muster. An act is how you go about modifying the Constitution or changing the Constitution. But you cannot have an act that violates the Constitution, or you cannot create a new act that violates the original act or intent of the act, because then you're violative of the Constitution, and by virtue of any means of expression, you as a legislator is to be considered to be a scofflaw. If that's what you're going to do, go outside of the bounds of the authority vested in you to violate the Constitution, the very Constitution that you swore allegiance to when you wanted to become the government of the country. Again, for those of you who are new to our program, you might say, or you might have the impression that I, the presenter of this particular program, is very forward in my approach and in my speech in regards to these matters. Why? Our country needs certainty. And certainty can only be had with truth and forthrightness and fortitude. It has to be delivered with a level of force and correctness, and or with a sense of I'm sorry, with a sense of vehemence, as you say, when speaking truth to power. You cannot go to these rascals as politicians who are doing the wrong things and just bow down to them, genuflect to them, implore to them, beg them, and do all whatever else you can do in order to hopefully get their acquiescence to do what's right. They took on the job, and the requirements for taking on the job is that they agreed to do what's right. But as soon as they get the power vested in them, they turn around and do what the hell they want. And they could care less about the public, they could care less about the laws, and they just move on with the authority vested in them to do as they please. And I personally cannot abide that, which is why every once in a while you might hear speaking in a derogatory way or in an offensive way or in some kind of way that maybe I should not be doing, because in the first place I'm speaking to people who are our leaders and who deserve to be given the respect that they are due by virtue of holding those offices. But I am no respecter of person. If you are going to hold an office and try to hide behind that office to do wrong, don't come in my direction, or don't expect me to sit by and pretend that, well, it's no big deal. Because as far as I'm concerned, I'm no respecter of person. Whether that person be the Governor General, the Prime Minister, any other minister, the police commissioner, any other authority in the police department, and or anyone. When it comes to my country, I'm a blood-sworn vanguard, and I'm willing to do whatever battle needs to be done in order for the preservation and development and well-being of my country. So if you as a politician offer yourself to do the job, the least we are going to expect of you, and I would expect of you, is to try your best. You may not be able to do the job properly. Maybe you might not be skilled enough to do the job. That's our fault for not figuring out who and what you're capable of before we elect you. So once we elect you, so long as you're trying to do the job, and if you're not competent and capable to do it, then we have to wait till the next election to get rid of you. But if we elect you, and you're supposed to be competent to do the job, and you're just being malicious and and malignant and selfish and disdainful and disrespectful to the people who gave you that power or authority to govern their affairs, then I don't mind taking on, the task to, tell you when you're out of order. You know, that's the least I can do. Again, I'm commenting a little bit. I'm getting a little extraneous, and maybe I'm overbearing at some point too. So let me digress and go back to the focus of the program. So, as I stipulated earlier, when they embarked on this agenda to try and alter the Constitution, they had not come to the people and request of the people, if they wanted that action to be undertaken. They just undertook that action without any consultation. And when they got flagged for it, they turned around and went to the House and created what I stipulated earlier as an act of Congress to so-called, at that point, attempt to legitimize their undertaking. Now, when they went and created that act of Congress, they made some big mistakes as well along the way. Procedurally, constitutionally, in apparently could have been in good faith, but end up being, malicious. And at the end of the day, they created what was then constituted with a new name. They gave up the Constitution Reform Commission as a title to the endeavor, and they called it a new name, PCC, People's Constitution Commission. In other words, they're going to blame the people for the outcome of whatever is it that they are undertaking. And they're not even informing the people adequately. They took millions of dollars to sponsor that activity. And that activity was supposed to have been to educate the people about what the Constitution was and have the people give them input in regards to what the people think that they would like to have changed in their Constitution. Instead of that, they turned around and they created a report on their own with the support of a few supporters, political supporters, and they did not do the education campaign that should have been done to educate the mass of the public. And they turned around and said that because they consulted a few people, and in their way of what they call consultation is to meet a few people, that showed up, a few thousand people that showed up at all the various meetings that they were having. Every meeting they had probably had, at the most, I think I recall, there was one instance when they had like 100 and something people, but in most instances they were like between 25 and 50 people, if that much, including all the people that was there as presenters. How the devil is going to take a small micro group in a society and pretend that micro group constitute a consultative process by which you gain acquiescence to a majority of the people in the country? When in fact, when the Constitution speaks about consultation, it tells you it is speaking about a referendum where the public, the plebiscite, participates and are able to say yes or no. And then from those who participate, you are able to say, among those, the majority of those who say yes carry the day. That's how our democracy is supposed to function, but not the way these jackals are playing around with the system. So they went to the House and made this act under the title of the PCC Act. It wasn't properly assented to, but it was assented. And at the end of the day, the ascension of that act, the powers that was granted to that act to the individuals that were set out as the commission, they turned around and made recommendations to eviscerate the head of state, as well as the governor general. That constitutes um, uh, what you say? Not treason. There's another term for it. Um, Anyhow, I'm babbling for trying to grab the word, and uh, the head of state, the legislator, and the commission cannot dispatch the head of state. Nor can the governor general dispatch her boss, who's the head of state, to whom she's a representative on behalf of the head of state. That's sedition. That's the term I was trying to recall just now when I was babbling and couldn't come up with the term. That's what you call sedition. They went and had the governor general, with the advice of the attorney general, for her to assent to something that I don't know if she did not read all of it or did not recognize that that ascension was for all intents and purposes to try and get rid of her and her position and her boss's position, to commit an act of sedition, by which if the head of state would have been aware that that's what the governor general had signed off on, she could have been vanquished as well, because the governor general serves at the pleasure of the head of state. For those who don't know, I would presume that by now most people in Belize would know and understand that to be the fact. Anyhow, we've been going through these processes, dealing with some of these recommendations. There's the 100 and odd recommendation. And every week when we have these teachable moments, we delve into one or two or three different recommendations that were of the group that was made. And tonight I'm dealing with amendment number 107, which says, let me go a little higher. Amendment number 107, which is to amend section 90. Now, when I say 90 as a number, I would hope that most Belizeans are familiar with that particular item or issue, because it's very critical. And from 1997, we've been dealing with this matter, trying to get the government at the time, from then till now, all the various governments that came into existence, to do what was required in terms of the redivisioning and reapportionment of the different divisions in our country, so that they can meet the requirements as stipulated in the Constitution under Section 90, to have nearly as equal a number of people voting in each and every division. It doesn't mean being exactly equal. It stipulates nearly as equal. It didn't say mandatory has to be exactly equal. So it gave a little leeway. But these jackals are not willing to conform to that, or accept that as a fair enough premise. They have some divisions that have 2,000 to 3,000 people, and other divisions that have almost 12,000 people. And each division get the same allocation of funds. Well, another way of saying it, the funds that is given to each division should be such that each division should have nearly as equal amount of funding per division, based on the numbers of the registered voters. I'll proceed to read further. It says, why I want to amend Section 90 is because of these reasons that they're stipulating here. Increase of electoral divisions, for example. Amend, repeal, and replace Section 90 as follows. So, Section 90, subsection 1, as they are proposing for them to appeal and amend, it says, the Institute for Election affairs, which again I'm going to have to elaborate on. Okay, most people in Belize that deals with elections understand that we have a department of the government that is called Elections and Boundaries Department, and over that department we have an Election and Boundaries Commission. All these things are spelled out in our constitution and the way they're currently supposed to be done, how it's supposed to be managed. We took them to court on 2 different occasions. We took the government to court on these matters. We won the case in one instance. They agreed that they were in non-compliance of Section 90 of the Constitution, and they begged the judge, instead of having the judge give a final ruling, the acknowledged breach of the Constitution, pleaded to the judge to allow them to go back and correct or amend their conduct and adjust the constitutional requirements. And when they didn't do it, when the judge went ahead and agreed with them to let us enter into an agreement, because all we wanted is for the government to have done what it needed to do, follow the Constitution and do what was right. That's what we sued them over. Mr. Wade, one of our other panelist members, was part of that group that sued them, and many others. I mean, we had quite a few programs dealing with that particular matter. During the time of the case, after the case, and even now as I'm having to refer back to it, because as of today, they still have not complied. That's the kind of jackals we are dealing with. The acknowledged deficiency in the court asked the judge to give them permission to go ahead and do what we were asking them to do in the first place. And because the people that took the case agreed to let them go ahead and do what was right, time passed by and they never did what was right. So the people went back to the judge again, asking the judge to please force them to comply. The judge looked at the people who was running the case, who submitted the case against the government, and said that for all intents and purposes, she don't believe their words, she accepts the government's word for it, that the government had acknowledged being in breach, and she had authorized the government to go ahead and make amends. And we had agreed that we should let them go ahead and make amends and do what was right. And because we agreed, we went along with that scenario. The judge is saying that from her vantage point, she cannot help any further. Because in her interpretation, she took 41 pages of documents, 41 pages to state out her basis for how she wanted to conclude the case, in deciding that we had then entered into what is classified under legal terms a tumbling agreement. She still had disposition of the case. It is under her judicial jurisdiction that the case was brought, and under her judicial jurisdiction and temperament that the case should have been dealt with as required by Section 20 of the Constitution and Section 94 and 95 of the Constitution, that gives the court unlimited jurisdiction to resolve any and all matters being brought before it. But because she is on the bench on contract as a foreigner to the country, that she is brought into the country on a contract, she don't want her contract to be disturbed. So whatever the government asks for, the government gets. That's not how judicial rulings are supposed to be based. It's supposed to be based on the law, an unsettled law at that, or stare decisis. It shouldn't be a willy-nilly judgment just because you are authorized to make a judgment, that you're going to just arbitrarily and capriciously undermine a case or throw out a case or dispose of a case without dealing with it, especially under the fact that it was a constitutional case. You just can't close your eyes and ignore the fact that you did not deal with the case or render a proper judgment on the case. And to facilitate the government to have the case being pushed away from the judicial system without it having been dealt with correctly. And then the lawyers, with their slickness, turn around and say, well, there's an estoppel when we attempted to bring back the same constitutional matter to the court with different plaintiffs, which we were told by the judge in her ruling that we were entitled to do. But because of what she's thinking of, this stumbling agreement became a flaw to the case. And therefore, when we brought it the second time, the slick lawyers on the government side is trying to claim an estoppel on the case and to say that the case was already ruled on previously. And for that, the next judge that was handling the second case, ended up putting himself in trouble because he lied on the court. He lied while sitting on the case, while the case was live in front of him. He called up the previous judge that had ruled and was consulting with that judge as to how they think that they should be able to dispatch the second case. Basically, they conspired. And then the lawyer on behalf of the clients pointed that out to the judge in the court. The judge turned around and said what the lawyer was saying wasn't true, when in fact everything was already on tape. So it was played back for the judge. And even then he was saying, well, that's not what he was intending, or that's what he was saying, when it was being said in his own words. That's the kind of scoundrels judges we have sitting on the bench. The same judge turned around and made some additional writing in a different case that another person brought regarding the same matter of this Section 90 issue, because that client had told the Supreme Court judge, the Supreme Court, the senior justice man, oh man, yeah. Anyhow, that particular gentleman had lodged, he and his lawyer had lodged a complaint against that judge, and that judge should have been sanctioned. Okay, because he basically impeached himself in his own words. Let me read some more of this stuff. Like I said, I know tonight's program would have been longer than our regular time, and I'm doing a lot of extra commentary in the interest of clarifying some points. I don't want to be stating points and people are not aware as to what those points really imply or are indicating. So I have a urge every once in a while to provide additional backup or backing or support or information for contextual purposes. So they have here now something that they would like to call, because it's not existing yet, this was part of the proposal. And this thing that I'll call it a thing that they were trying to pull fast, they say the Institute for Electoral Affairs shall, this is their proposal now, and you know what they're referring to when I say this thing which they're calling the Institute for Electoral Affairs, is our Election and Boundaries Department. Okay, that's how we know it to be. The Election and Boundaries Department that deals with all election matters, and operates under an existing election and boundaries commission. But in their proposal, they're proposing to have a separate entity, or at least maybe the same entity, if I'm to give them the benefit of the doubt, just with a new name. And they're saying that new entity by the name of the Institute for Election Affairs, Electoral Affairs, shall, after considering the distribution of the population throughout Belize, which is what the election and boundaries does, as I previously described, make proposals for every election, for divisions, for dividing Belize into electoral divisions in such a way that all of that is already stipulated in our current constitution. So what is new that they're trying to do other than just changing the name of the election and boundaries division to the new title that they have put in here? And this new title that they put in here is being hauled and pulled so that it doesn't operate, or it will not have the same authority and power vested as the current election and boundaries have, because the current election and boundaries operates under the authority of the head of state, and thereby under the governor's seal. And because, as we had read in previous presentations or other teachable moment presentations, we have read where they're attempting to try and eviscerate the office of the governor general as well as the office of the head of state. Then under this new title here, for this new division that will not have the same powers vested in it or being controlled by, is how they are going to try and make this thing work. Now, I'm saying that to give the benefit of the doubt to those who may not know about the other background or information piece that we have dealt with before and that we'll be dealing with in the future. And the reason why is because not everybody is on top of these details. As the presenter of this material, I have to make sure that I am on top of it, because my credibility, is at stake. So I got to make sure that what I'm presenting, people can understand and that it holds water within the context of what they're proposing and what the Constitution says. I'm just an intermediary. And for my effort to succeed, I can't be found wanting in terms of conflating the facts or lying or misinforming the public. So I'm very, very cautious when it comes to that part, okay? Under paragraph A of their recommendation, it goes on to say, each electoral division shall have, as nearly as may be, an equal number, consistent with the population growth, of persons eligible to vote, with a standard division of no more than 5%. They don't have the word variance, but I presume that's what they're trying to get at here. So I'll just include that one word for clarity purposes. With not more than 5% for each election. And like I said, they left out one word. And that one word that would have made the difference in comprehending what they're saying here, because to anybody just hear me read what I read just now, they're still probably trying to figure out what does that mean. And it's all because of one word being missing, okay? And that one word, I'll put it in now and I'll say, consistent with the population growth of persons eligible to vote, with a standard deviation is the term, a standard deviation of not more than 5% for each election. It should be for each electoral division. In other words, when the Constitution, as it's stated in Section 90, that the election and boundaries is supposed to make sure that no division has more than the other, or that every division must have nearly as equal a number of votes. It's specifically requiring that you don't have one division with 2,000 to 3,000 people and another division with 11 to 12,000 people. That's not nearly as equal. And that's what we have right now. And we have been fighting them to try and correct, and they refuse to correct it. We're going to enter into another election in a few months' time. Okay? The City Council and Town Board election at the turn of this year. And they still haven't completed this exercise. But so many decades? Not to say the least that in some, like for example in Stan Creek, you have 4 divisions. One division has, like I said, almost 12,000 people. And in that district of Stan Creek, they should have had at least 6 representatives instead of 4, because of the amount because of the population and the wide disparity. Whereas in Belize, you have 13 divisions in the district of Belize. And that district of Belize with 13 divisions, one division has just about 2,000, another division has about 3,000, another division have about 2,500, which is somewhere in between. But you have 3 divisions, or probably 4, because if you include you have Fort George, you have Mesop, you have Albert, and you have Mesopotamia, not Queen Square, all of which are micro divisions, none of which have more than 4,000 people. So somehow they will have to collapse a couple of those divisions, but we haven't gotten there yet. I'm talking about something that's yet to be considered or to be tackled in the future, if they ever get around to do it. Because if they have been playing games for the last almost 30 years, another couple of years will make them about 30 years since they've been, refusing to deal with this matter. And government come in and go out. Next government come in and go out. And the next one come in and go out. And they all promise that they're going to deal with it before they get elected. And after they get elected, like I said, who cares? They move on. They fill up their pocket and help their friends and whoever else not. And that's it. That's what the name of the game is. The big hustle. So the whole of this paragraph A is already spoken for in the current constitution. Under section 90, subsection A. Now they're stipulating it here as if they're putting something new. That's why I want to change the constitution, to put this in and take out what is already there, which already speaks to this point. I guess that's where the millions of dollars is going that has been allocated for the project. I'll read paragraph B of the same proposed section that they have here, which goes as follows. The total number of electoral divisions for the House of Representatives shall be not less than 31, which is currently what we have. Okay. And before they do a redivisioning, right now we have 31 divisions. Before they do a redivisioning to decide whether they're going to increase the divisions or just leave it as it is, they have to do the reallocation or reapportionment. And before they do the reapportionment, they have to have a re-registration, on the basis of which then they can have a reapportionment. So once they have the re-registration, and by the way, we have had various re-registrations in the past over the same period of time. So it's not because they couldn't have gotten the information or the number of voters, because every time before there's an election, they have new voters and they have voters who switch divisions. So every so often, when they do that, they're at a point where they have the equivalent of what would be constituted then reapportionment, for lack of another way of expressing the action. And once you have that reapportionment, then you can take that reapportionment and redivision based on the standard that you set up or the requirements that you want to abide by. That is to say, if right now you have 100 and something, I think it's a little less than 200,000 voters, and you have 31 divisions, it's somewhere about around 6,000 plus that you'll have as a median number. So then why can't you carry up or take up to about 6,000 those divisions that have 3,000? Collapse a couple of the small ones then, like I stipulated earlier. But that means that you will be having the collapsed divisions will reduce the current number of divisions to less than what we have. And then what you can do is with the divisions that are so far over 6,000 as a median, all the way up to 12,000, you collapse some of those, or you take off half of one of those, or 1/3 of it, and add it to another 1/3 from another division that is high up at those numbers too, and create a new one. The bottom line is you could end up with probably the same 31, right? Just by spreading your numbers almost as equal. And or you can add a couple of more divisions. That's and they have a full staff, 24, not 24, like a full staff that works 8 hours every day as a minimum without overtime for all the days and weeks and months and years that we've been pursuing this process. And they pretend that they still have not been able to do it, when we have shown them with computerized system that the whole matter could be dealt with in less than a 1 day time by one person in less than 8 hours. We have made presentation on this particular platform to show how it's done and how quick it could be done. Each division will take less than 5 minutes, between 3 and 5 minutes to have it done. So if you multiply 31 division times 5, okay, and then you divide that by 60, that will tell you how many hours you need, which is less than a day's work for one person. By the way, we're not talking about a whole staff like what they have on right now, dozens of people sitting around in those departments, okay? But when people don't want to do what they're supposed to do, and the people with authority don't put their foot down, then what needs to be done, doesn't get done. And they keep making excuses year after year after year. Anyhow, I'll read paragraph C of this same section here, which goes as follows. The total numbers of electoral divisions for the Senate shall be 12, with 2 from each of the 6 districts. Now, they are proposing now, according to this, to alter the way how we get our senators them into those offices. Because currently, the senators are appointed, and there are methods and means and ways how you get about to appoint them. According to this proposal here is that you will have 2 senators from each district, which will be 12, as compared to what we have right now, 6 senators from the ruling party, 3 from the opposition party, and 4 that are what they call the something partner. I'm drawing a blank. I don't remember. But I know the term, but I just can't bring it forward. But anyhow, so we actually have 13 senators right now, okay, an uneven number, so that you could always end up with with probably a majority, you know, on one side or the other. The way they are presenting it here now is that they want like 2 senators from each district. So we'll go back to where we were before with 12 senators as compared to now that we have a 13th senator. Okay. I have no issue. I don't want to fuss over that particular recommendation. I'll just move on and read paragraph D of the same section. It says, each member of the House of Representatives shall be elected to serve a term of 5 years, which is currently what the status is. There's nothing new there. For each electoral and for each election, and he or she, they have he here instead of he and she, because obviously you have female members of the House of Representatives. They're not all he's. So a simple little basic thing like that, the basic courtesy of, giving the female gender recognition within the proposal or presentation here is absent. That's how callous they are, indifferent. So they say, and he shall. I would like to retrogress and go back and say, and he or she shall have been 25 years or more, having lived 8 consecutive years prior to the time of nomination for election. I presume that they're trying to say the individual, he or she, shall be 25 years of age. They're trying to set a standard for minimum age for elector to be elected to the House. And then it says, or more, and having lived 8 consecutive years prior at the time of nomination for election. And that's an incomplete statement. So the draftsman is falling on his heels again there, because there's a failure to explain what the living 8 years is intimating. And I would presume that they're trying to make a bar there for people like myself and maybe others who are not living in the country 8 consecutive years. That's the point that I think they're trying to address. So they would have said then, having lived in the country 8 consecutive years prior to or no, it says prior. It says prior. It doesn't say prior to. It just says having lived 8 consecutive years prior, and that's semicolon. As I said, they're not clarifying or correctly intimating what the 8 years is for, other than the fact that I presume they're implying that the 8 years lived is to be lived in the country of Belize. So they're putting another bar there on what allows a Belizean to have the right to put themselves up for election in the country for a division. When in fact the Constitution says that there shall be no discrimination and everybody is entitled to the same rights. So they're, again, in trying to making such stipulation, what they're doing is contravening the Constitution again. The Constitution precludes them from making any recommendations or making any law that discriminates and that bars or takes away any Belizean's rights, fundamental rights or rights of a Belizean citizenship. the government or no officials have the vested power, authority, or constitutional right to disqualify a Belizean by virtue of putting any such stipulations as they are doing here, saying that unless you have lived in the country for 8 years, you can't run for election. That's basically what they're talking about. So there's a thing called I wouldn't say there was, because it still is. It's just in abeyance or right now, set aside. No? One of those proposals that was made and they put them aside. Amendment 7 to the Constitution of Belize. Okay, in which some of the same onerous type recommendations were being made to block off Belizeans who live abroad or who travel abroad from being able to exercise their rights in the country. I can't take this call. It's an important call, but I'm in the middle of my program. I can't. So I'll just have to. I should stop ringing because it's covering up what I'm trying to read. I'm sorry, I can't take it all. I'll have to decline. I just have to push decline. I'm not used to declining people's call when they call, but right now, it's too much. It's too much distraction for what I'm trying to focus on. As I said, each member of the House of Representatives under this recommendation, paragraph D section, says each member of the House of Representatives shall be elected to serve a term of 5 years. I have no problem with that, and that's the way it's currently stipulated in our laws, in our Constitution. For each, it goes on to say, for each election, and he shall have been 25 years or more. Now, that's a problem right there. It's another constitutional violation because it's a discriminatory marker or bar, because the Constitution says that you're entitled to vote at the age of 18. Okay? And whenever you become at the age of 18, which is a majority age as is classified under the Constitution as an adult, your rights is prohibited, it's prohibited of the government to discriminate against you and to say that you have the right to vote, but you don't have the right to run for election. In other words, they can't say, well, you're at 18 now, you can vote, but you have to be 25 before you can put yourself up for election. That disqualification is impermissible, and so it's violative of the Constitution. And whoever is putting together that particular recommendation is either ignorant of the fact that the Constitution speaks to those matters clearly as being, the way they are putting it, and a recommendation or a law, if it becomes law, an illegal or unconstitutional, an unlawful law. There's no such thing. If it's unlawful, it's not a law. If it's unconstitutional, it's not a law. If it's illegal, it's not a law. How many different ways does it need to be explained? You cannot make an unconstitutional law to violate the Constitution and pretend that it is valid, viable, legal, and lawful or constitutional. It is none of the above. The problem is that those matters need to go to a court for a judge to make that ruling. And in the meantime, elections are being held without those matters being considered because they are not being taken to court for a ruling. That's why these jackals get away with oppressing, suppressing, you know, and intimidating the society and acting like scofflaws, like I said. Something is going on here. Let me see what it is. I think one of my wires might be. Let me double check. No, no, it's all right. Just a second, please. My battery stuff. It's giving me an error message saying that my battery is about to go low, and it shouldn't because I have it connected, unless it's unplugged somewhere. Oh man. Oh, that's why it was. Okay, I got it. I got it. I'm sorry about that disturbance just now. My battery was going dead, and the computer was giving me an indication that such was the case. And I checked my wires, and it was all good initially, but I guess I probably pulled it with my foot, so it got unplugged, and therefore it was running down. Um, Nevertheless, let me stop elaborate commentary on extraneous issues right now. I need to get back to the part that I was reading. Okay. Um, so, as I said, this particular recommendation, paragraph D, I don't have a problem with the first part of it, but I do have a problem with the second part because the second part is violative of the Constitution. In other words, they're discriminating, and that's impermissible. First of all, they're saying that the person have to have 25 years or more before they can put themselves up for election, which contravenes the right to exercise your adult suffrage rights, which was authorized from way back in 1956, I think it was, somewhere in that vicinity. I don't recall the exact date. I know they're coming with this stupid recommendation here as if they don't have any knowledge of those things. In other words, why do they put people to make recommendations on issues that they're unfamiliar or unaware or ignorant of? It doesn't make sense. That's how they create controversies and legal challenges, and and they're being paid to cause all this mayhem. If their salary would be deducted for doing the wrong thing, you know, or if some of them would suffer some penalties for engaging in these type of activities or bastardization of the Constitution, then they will be more meticulous. They'll make sure that at least they get more qualified people who know what the devils they are doing, rather than paying a salary to some friends to make onerous recommendations or recommendations that doesn't square with what is legal, lawful, or constitutional. And they have a lot of lawyers among themselves, and they can afford to hire additional private lawyers, as they always do when they really have a case to answer. So why don't do the right thing right in the first place? You know, and that's where I have my difficulty with some of them, and which is why I keep you know telling them like it is, whether they like so or not. The bottom line is somebody needs to holler or make requests for some accountability. So again, that was violative. And then the next part here, which says, having lived 8 years consecutively in the country, which is what they were implying at the time of the nomination for election. That's incorrect. They cannot put those kind of bars or standard. Once a person reaches the majority age of 18, they are able to exercise all their fundamental rights as an adult in their own rights, and accept with their consent no authority, power of government or officer of the government or any authority as the Constitution stipulates it has the right to deny them of any of those privileges. Once you get to the age of 18 and you want to run for an elected office, of course, trying to run for an elected office means that you have some sense between your 2 years at least. You have acquired some kind of a knowledge, understanding, and awareness as to, what is required to perform the functions. But it doesn't mean that because you arrive at 25 years, which is what they're trying to put here as a bar, that at 25 years you have acquired all those skills. You have people who are less than 25 who are much more skilled than some individuals who are 25, and some individuals who are 25 who who have learned nothing. But by virtue of becoming 25, then you're saying that they then qualify to run for office. The public decides that. The public should decide whether or not that person, they think that that person is capable of representing them. It's not for the government to decide on their own arbitrarily and capriciously while violating the Constitution itself to make laws that are arbitrary and capricious and that is violative of the Constitution and that is inconsistent with the Constitution. There are people who are knowledgeable enough who are supposed to be involved in these processes to rewrite a constitution or to alter a constitution. You don't get any Tom, Dick, and Harry or Mary Jane or whoever else, on any kind of drugs or whatever, to just sit around a table and write out any kind of craziness while being paid at that. Come on. I'd like to go back to paragraph E. And paragraph E speaks about each senator shall be elected to serve a term of 6 years for each election, and he or she shall have been 35 years or more, having lived 12 consecutive years prior at the time of nomination for election. Again, they miss out here what the intent of the having lived 35 years is all about. In other words, because they are writing this in Belize, it is to be presumed that everybody understands that that's what they're saying. You're trying to modify a constitution, and without, in a time and age as 2026, you're taking it for granted that you don't have to write it down in black and white. The previous constitution that we have, or the one that we have currently, because you can only have one constitution at a time. This issue here is a proposed stuff that they were trying to put together, okay? So how can they say what they're saying here without specifically clarifying what they're saying? For this type of endeavor, as serious as it's supposed to be, you can spare one or two words that is necessary to clarify to a basic student or somebody who is going to read this stuff, or even the legal minds who are going to deal with this stuff. Because by leaving out one or two or three words like they are doing here, a lawyer could take these things and spin it around and come up with a complete different conclusion. That's how lawyers win cases. Because of bad drafting, bad legal drafting. But I shouldn't be able to tell them that, I bet you. But at least they wouldn't want to hear it from me. It doesn't matter. I'll still tell them whether they want to hear it or not. Get their act together. They're collecting a fee for it. They're charging money for it. They're being paid for it. Millions of dollars. So don't come crying to me about, why is it that they didn't do what they were supposed to have done? The money was there. The money was paid. The effort was supposed to have been expended. And the crap that we have here as an outcome or as a result doesn't cut mustard. So if you want to get vexed with me, whoever, for telling you as it is, then unfortunately that's your problem, not mine. Then again, they want Each person who would want to run for senator in the new configuration of things, of course, compared to what we have right now, each person would have to have, they will run for a term of 6 years, and they would have had to live in Belize at least 12 years, and their age at that point would have had to be 35 years and more. Now, I explained to you earlier that they're transgressing the Constitution by stipulating these ages, right? That is to say, let me explain something else to you that these knuckleheads are trying to get at here, okay? If let's say you as a person under their category here try to run for office, you would have to be 25. That's what they first stipulated. You'd have to have lived in that area at least, I think it was, what was it, 8 years? Or 10, what was it? 25 years and 8 years, 8 consecutive years. That is that you could not have been out the country at any time during that 8 year period. Otherwise, you get disqualified from being able to run. Uh, I'm laughing because I could see scenarios where some of these matters would be taken to court, you know, and these people would just be laughed out of court, you know, because they're just saying things here that doesn't comport with the facts, that are inconsistent with the Constitution. And on that basis alone, it would be struck out. But anyhow, again, let's go to paragraph F, which deals with the Prime Minister. It says, a Prime Minister and a Deputy Prime Minister shall be elected every 4 years per term and shall serve no more than 2 terms, and each shall have been 35 years or more at the time, and shall have been shall have lived in Belize 10 consecutive. Now you see how they clarify. You see what I was beefing about earlier? How no, someone got around to the idea that this is how it's supposed to be structured, right? They could have done the same thing on the other occasions above that we just spoke about, that I was complaining about, and at least having recognized that they were, you know, stepping on their own toes as regards to the previous sections. After writing paragraph F, they could have gone back easily before presenting this stuff to the Prime Minister and not having to read about it in public to you, the listeners of our particular program, and complaining about it. They could have just as well gone back and correct the other ones then too. Because this one would seem or appear, to have been drafted adequately, at least. Let me put it like that. At least adequately. Correct the other ones then. Don't publicize the stuff before. Were they so lazy? Or were they running out of funds to the point that they didn't have time to go back and correct their errors, omissions, or oversights? We're dealing with a serious legal document, the Constitution of the country. A proposed constitution, by the way, I'm sorry. It's not the real constitution yet. But a proposed constitution of the country, which will replace the existing constitution at some point if they were to be successful in their endeavor. Of course, I wish them not. Right? But that's a different story or a different discussion. Let me go on to read this portion here. A prime minister and a deputy prime minister shall be elected every 4 years per term. Well, as a 4 years as a term, and shall serve no more than 2 terms, and each shall have been 35 years or more at the time, and shall have lived in Belize 10 consecutive years prior of their nomination for election. Okay. As we have it in our constitution right now, the prime minister can serve 3 terms instead of 2 terms like what they are recommending here. And those 3 terms that they can currently serve does not have to be consecutive. Okay? And the Prime Minister currently is a member of the party that he runs with as a team. As a matter of fact, he doesn't run for the position of prime ministership. He runs for a position as a member of parliament, and it is the majority members of parliament that decides who they will have as their prime minister, the leader of their party or whoever they choose as the majority parliamentarians. Okay, that's how it is right now in our current legal system, our system of governance. Under the Separation of Powers Act, our present system allows for the prime minister of the country, like I said, to be elected to the House of Representatives, and then those people, as a majority parliamentarian, decide who among them can become or would become the prime minister, and that prime minister then recommends who the members of his cabinet will be. The way they are setting it up here is that in the new configuration, if they were to be successful, the prime minister would be someone that would be voted for directly. So you'd have individuals who put themselves up to run for the position of prime minister. And what I was intending to try and explain earlier is that if a person in the House runs for election and win 2 times, then that person is termed out. They cannot run again for the House. They probably could run for the Senate and serve 2 terms in the Senate, and then after the Senate, they can go ahead and run for the position of prime minister. At least that is what I would believe that these people are trying to intimate or a point that they are trying to arrive at. Okay, if I'm to contextualize what they have here as a recommendation, they are not saying all of that I just said, but for all intents and purposes, it could be understood as being such. Of course, if you run for the House of Representatives and you get termed out of the House of Representatives and you want to run for the prime minister, are you telling me that you cannot run for the prime minister? When I come to them, in order to run for the House of Representatives, you must be 25 years, as based on this recommendation here, you must be 25 years or older. So if you are 25 when you win your first election, by the time you term out 2 elections in a row, 5 years per term, you'll be 35. So if you don't win any more elections after that, in terms of the House of Representatives, you can then put yourself up for prime minister at the age of 35, right? You don't have to go and be a senator for 10 years. According to their recommendation here, you should be able to run for prime minister at that point. That's not what they're specifying. But I arrive at that as a conclusion in terms of how they are running the numbers and how they hope to be able to get a prime minister or somebody that is what you'd call would have enough gravitas and experience politically wise that they would probably have been a House of Representative member and then would have gone on to the senior body, the Senate, spent maybe 10 years there, and then get termed out there, and then having acquired enough political savvy or knowledge, then be ready to run for the office of prime ministership. I don't have a problem if that is really what they're trying to intimate. Spell the damn thing out is my current issue. Say what you mean and mean what you say, because that's what the law is going to become if you're successful in allowing that to become the constitution. That will become then the dictates of the constitution or the prescripts of the constitution. So spell it out. You have enough information in here right now that I was able to figure that out, and I would presume other people should be able to figure it out just as myself. But a lot of people don't know nothing about the Constitution. They have never seen one. They don't understand what it's all about. They have never read one. But at least, as a basic principle in good draftsmanship, spell the thing out so that those who are interested and who do make the effort to try and learn and understand these things can follow the dots, you know, from one point to the other. Um, I'm running up against time now, and like I said, I knew it was going to be a lot of stuff that I wouldn't be able to cover. Nevertheless, I still want to pursue a little bit further. I'll go to paragraph G of this same section, which reads as follows: the electoral divisions for Prime Minister and Deputy Prime Minister shall be the entire country of Belize, from the Institute of Electoral Affairs, list of all the registered voters. Now, it should be clearly understood here what they're trying to get at, or at least it's easier to understand this particular um, paragraph G, in that they are intimating or saying that the base of voters that the Prime Minister would need to garner his electoral position from would be the base of all those who are registered voters in the whole country of Belize, as compared to the Prime Minister, as compared to just a member of the Senate who would be elected in a district, or the member of Parliament or the House of Representatives who would be elected in a division. So this one is plain and straightforward, okay, easy to be understood. At least I would hope that would be the case for the Prime Minister and Deputy Prime Minister, who shall be the entire country of Belize. And then they keep repeating here the Institute of Electoral Affairs. You know, that's one term that they're trying to foster on us as a new name for what is currently known as the election and boundaries, because they are the people that does the re-registration, the reapportionment, and the redivisioning. That is a matter that is the responsibility of the election and boundaries, and now the new name that they would want to call it, the Institute of Electoral Affairs. And that's the end of that particular part of the presentation there just now as regards to uh, section 1 of that recommendation. We also have section 2, section 3, 4, section 4, which altogether comprise all the reading that I would have liked to have done for tonight in order to complete the presentation of recommendation number 107 before getting to 108. And the amount of time I have left, 29, oh wow, I have about less than a minute. So I cannot, like I said, I knew I wasn't going to have enough time. I intimated that, I pointed that out to you, my gracious listeners, as a heads up. And whether fortunately or unfortunately, it became the point. That is that I'm running, or have run out of time and haven't been able to complete that part of the exercise. I would have liked to have had at least another 15 more minutes. I don't know. If I take 10 minutes right now, I could probably, what is that, 29? Yeah, it's 30. Um, you know what? I wouldn't like to leave the rest of this stuff for the next occasion because doing so would require on the next occasion to come back and preface again for contextual purposes, right? What was being said before I get the chance to read it. So I'll just indulge myself in another 10 minutes, I hope, and maybe just read off the stuff without any comment. And then maybe if I have any more time left within the 10 minutes span, then I could just make a small, simple comment to close it out. Um, I wouldn't like to leave this subsection 2, 3, and 4 hanging. So please let me just go through it and read it if you would bear with me. Uh, Subsection 2 reads as follows: in fixing the boundaries of electoral divisions, the Institute of Electoral, I need to make this smaller because it's too big. Can't, it's overlapping. Yeah. In fixing the boundaries of the electoral divisions, the Institute of Electoral Affairs shall have regards to the transport and other facilities of the division and to its physical features. This is already written exactly, almost word for word, in the current constitution, so there was no reason for them to even tamper or try to bring this up, you know, to allude to the idea that they're stipulating something new and or making corrections, because that's not the case. Section 3 reads as follows. I'm trying to just rush through the thing because, in the interest of time, so I can close it off. Section 3 reads as follows: the proposals of the Institute of Electoral Affairs made pursuant to this section shall be laid before the National Assembly, which is already in our current constitution as well, by the chairman of the Institute, and the electoral divisions specified in those proposals shall be the electoral divisions of Belize for the purpose of any uh, law for the time being in force relating to the election of members of the House of Parliament, Senate, Prime Minister, and Deputy Prime Minister shall not be such electoral divisions until it's what, enacted in as a law by the National Assembly. For all intents and purposes, what they're trying to get at there is that um, exactly as we have it right now, that is that under Section 90, the Election and Boundaries Commission is required to perform these functions. And it tells them under 90 subsections and 91, I think, and 92, uh, basically almost word for word, except here, the only difference here as compared to our current constitution is where it's talking about the prime minister having to run for election in the whole country as their base, or as their, they're not running in a particular single division that they win as it currently is right now, where where the prime minister currently, Mr. Briceño, ran in the Orange Walk Central Division and won, and therefore among his colleagues, you know, they look at him as the leader of their party and the leader of government business. So then he, as the leader, is appointed by the Governor General as Prime Minister, and he then chooses the members of his cabinet from his elected officials or from the Senate for those whom they appoint to the Senate when need be. But that's those are extraneous and further issues that require additional expanded reading and discussions on. So let me just quickly read off section 4 here, just to close out, as I said, this particular issue. Under section 4, it says, when the Institute of Electoral Affairs considers it necessary to increase or decrease the numbers of electoral divisions, which is almost word for word existing in our current constitution as referring to the Election and Boundaries performing those same functions that I just read about. As specified in subsection 1, it shall make proposals to the National Assembly, which we already dealt with under section 1, and which I already explained exists currently in our Constitution. And the National Assembly may create a law to give effect to such proposals with such amendments and modifications as may seem appropriate to the National Assembly. All of that is already stipulated in our existing Constitution. So, as a matter of fact, then, the majority of what is being spoken to here in this uh, recommendation number, let me go back and specify, um, 107, almost all of what is being proposed here right now exists in our current Constitution. So, by virtue of my sense of awareness, there shouldn't be any need for them to have even waste their time writing all of what they wrote here. I mean, they could have probably, in one paragraph, said all of what they have said here in 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 paragraphs. They could have said everything that they have said in these 13 paragraphs in just about one paragraph. Okay? But we have come to the ending of our program for tonight. We have surpassed our allotted time, and I beg your indulgence just now to hang in there with me for another 10 minutes just now so that I could have finished off that particular recommendation so we don't have to go back to that and try to explain it and contextualize it next time. Next time we will deal with some other issue. Thank you very much for those of you who listened to our presentation or teachable moment presentation for tonight, Constitutional Night. And those who will be listening to us over the weekend and at other times at their own convenience. I just want to express my gratitude and thankfulness to you for having spent your valuable time listening to me babbling in your ears, trying to provide information that you, the Belizean people at home and abroad, need to be aware of. Because at some point in time, these jackals are going to come back to us with these same recommendations. I don't know if they're going to change some of them or they're going to add some of them. It was always from the very beginning when they said they was going to undertake this task, I pointed out that they had hidden agendas, and the way they drafted the act that they took to Congress and passed is to allow themselves the flexibility to be able to decide whether what was presented to them by virtue of that act through the PCC commission would be substantive enough for them to take it as it was recommended and just pass it as an act to modify the Constitution, or to eviscerate the current Constitution and replace it with what was recommended here in this particular report, or as they stated in that same act, they would have the right to then decide if there would be any need for a referendum. When in fact in the act it specifically says that there shall be a referendum as well. And even the Attorney General as well as the Prime Minister, when they were questioned on those particular points, stipulated that yes, there's two different referendums that we're talking about. One that is in this particular PCC Act, as the knucklehead Attorney General had told us when we were trying to pin him down on the issue and show him that they had some deficiency in terms of what they were referring to. He lied to the public and said that there were two referendums and there are two different things that they have to deal with, and they had to wait for this issue to be resolved and the laws to be passed into place and the new constitution to be put into place for them to address some of the things that they needed to address that people were demanding of them to address. As regards to the Oceania referendum and the other referendums, they said they could not address those and they wanted to wait. Now this so-called proposal is still sitting on somebody's desk somewhere gathering dust, while then they fail to act on the existing constitution that we have and abide by that existing constitution, and then, until they could have gotten another one that they were trying to get in place. They refuse to abide by the current constitution, and they keep acting as scofflaws. They keep violating the present constitution. And there's only one constitution at a time. So they could not be violating the existing constitution and pretend that this, which is what they want to replace the present constitution with, was already law or lawful or constitutional. Because it is not. But yet they're trying to run the country as if this junk was already in place, substituting our present constitution, and therefore they should not be considered as being scofflaws. Thank you very much. Like I said, again, we have gone beyond our program time. Uh, Looking forward to see you on Monday when our next presenter, chairman, would be available for the Monday night programs. And like I said, I appreciate very much the fact that some of you have taken your time to listen to our program, either now, later on, or at some point in time at your convenience. God bless Belize and Belizeans. I hope that you have derived some positive public benefit from this presentation. Good night and goodbye.